Dear ladies and gentlemen, dear friends and supporters of the Käte Hamburger Center for Advanced Study, Law as Culture. We would like to cordially welcome you to the upcoming online event in our forum series, Law as Culture. Professor Antons is joining us from Newcastle in Australia. How often must he have heard the semi-funny joke that talking with him about legal pluralism would mean to bring colds to Newcastle, though this is another Newcastle in Australia than in England. In German, we call it Eulen nach Athen tragen, pretending more classical erudition that one really might have in the end. Professor Dr. Christoph Antons, professor at the Law School of the University of Newcastle, is currently fellow at the Käte Hamburger Center Law as Culture. That is in digital format because traveling to the River Rhine was not achievable, unfortunately, so that we can profit from his extraordinary knowledge only from a distance. Today, he will present his research project, Peranakan Chinese in Indonesia. You will certainly, at the end of the conference, have transmitted to everybody how to pronounce correctly the construction of a community in colonial law and its legacy, thereby touching a fundamental problem in society. Class, status, ethnicity, and gender are main lines of constructing the societal community of a society. The extent to which law operates as a medium of this construction, solving or intensifying the resulting tensions of the plural society, leads to the core problem of the current research phase of the center, namely, which is concerned with the relationship between the legal and the communal sphere. We are touching also a functional realm of the law that is very often underestimated, that it is namely its function to be part of the processes and dynamics to construct collective identities. And this is an interesting subject in itself. So in his proper abstract, Christoph Antons has developed the basic problematic as follows. When it comes to representations, I quote, of communities in post-colonial societies, it is very important to distinguish between self-defined notions of ethnic identity and ethnic categorizations imposed by others. Colonial administrators in particular tended to classify populations in accordance with the economic and political goals of the colonizing power. Different communities were split or lumped together under legal and administrative categories, which would define their access to law, economic opportunities, and political office, end of quote. The lecture will show, as Christoph Antons concludes, how competing visions of ethnic versus civic nationalism in Indonesia are visible in discussions about the integration of ethnic Chinese, that is the respective community we are talking about, and their equality before the law, or the denial of equality before the law. Professor Antons is particularly prepared to solve the riddle of identity building by way of the law, for he studied not only law, but also Southeast Asian studies, art history, and anthropology at the universities of Munich, even the charming and provincial city of Bonn, whereby he has still connections to Thomas Dreyer, for example, Mainz and Passau. He obtained his doctorate in law from the University of Amsterdam with a thesis on property law in Indonesia. So, since a long time, a special interest in this area of the world. Since 2016, he is a professor at the Law School of the University of Newcastle, Australia. Previously he was professor at Deakin University in Melbourne, University of Wollongong, associate professor. With Wollongong, we have a lot of contacts, of course, because of their relation and interest in law and culture. Of course, associate professor at Charles Darwin University in Darwin, as well as senior lecturer or lecturer at La Trobe University in Melbourne and Griffith University in Brisbane. In addition, he was visiting professor, visiting research fellow, and senior fellow at, among others, Stanford Law School, the International Institute for Asian Studies in Leiden, Netherlands, the Graduate School of International Development in Nagoya, Japan, the Max Planck Institute for Foreign and International Private Law in Hamburg, Singapore Management University, and the University of Melbourne. I'm not just quoting it, all of those affiliations in order to make eulogies to institutional achievements. It is just a simple reality, and we must know it in order to understand where all his knowledge comes from. Currently, he is visiting professor at the University of Technology in Malaysia, affiliated research fellow at the Max Planck Institute for Innovation and Competition in Munich, senior fellow at the Center for Development Research at the University of Bonn. By the way, a pleasure that I proudly share with him, and senior associate at the Center for Indonesian Law, Islam and Society at the University of Melbourne. And it continues. I think he will not blame me too much if I will shorten a little bit at this point in order to conclude that since October 2020, you are a fellow at the Käte Hamburger Center, Law as Culture and Bonn. Of course, most of us present their professional identities by way of alluding to the publications one has done. The list is so long that I just refer to the selected bibliography that he himself has put on our website, and I may just mention some of them only. For example, intellectual property, cultural property, and intangible cultural heritage from 2018, Routledge. The Handbook of Asian Law. Unfortunately, I still have not seen it. I'm absolutely interested in having access, especially to this book, Intellectual Property and Free Trade Agreements in the Asia Pacific region, Law and Society in East Asia, published with Ashgate, meaning that in earlier publications, the relationship of law has always been one of seeing the law as part of the wider societal context. So law and society and culture has always been a predominant topic in your writings. Globalization, developmental questions in East and Southeast Asia, intellectual property questions are expressions of your specific interests in a broad field, in a wide field, but very specialized in the same time with regard to the region that you know best, if I understand well, or at least you think worth of being published about. You will have now the opportunity to convince us that we should know much more about Indonesia. I'm very happy that Martin Ramstedt, a further specialist of Indonesian society, is with us. By the way, director of the Onyati Institute in Onyati about law and society. And there will be further people to attend your conference, and we are really very curious to listen to you. And the floor is yours. Very welcome again at the center, at the Käte Hamburger Center for Advanced Study, Law as Culture.
Thank you so much, Professor Gebhardt, for this very friendly introduction. I'm very happy to be speaking in this forum. And I would like to begin my presentation with this map from the National Museum in Jakarta, which shows the diversity of ethnic groups in Indonesia. People with a migrant background, such as the Chinese, are not included in this map because it relates to people with territory and language. Another representation of ethnic groups can be found in the census data of the Indonesian government. And it says there that there are some 300 ethnic clusters with 1,340 ethnic groups. 98% of these are indigenous to the archipelago. They are distinguished according to their place of origin and size. 5% are foreign minority groups, such as ethnic Chinese, Arabs, and Indians, who live predominantly in cities. Who are the ethnic Chinese in Indonesia? I thought I'd show you some pictures to get a physical impression. Here is a Chinese wedding, in fact, in Tang Dynasty attire, because the people call themselves the Tang Lang. They go back to the Tang period in China, in their presence in Indonesia. And this is one of the poorest communities, Chinese communities on the outskirts of Jakarta, and one of the few active in agriculture, the so-called Banteng Chinese. According to the census, Chinese account for 1.2% of the population, or just under 3 million people. And although the census is formally based on self-identification, the representation continues to relate Indonesians of Chinese descent to China and to classify them as Chinese, together with recently nationalized migrants from the People's Republic and Taiwan. So you see here under number 7, China, RRC, China, Taiwan. This occurs in spite of a change in citizenship law that everyone born as Indonesian citizen who has never acquired another citizenship is now indigenous Indonesian. As the census shows, Indonesians of Chinese migrant descent, the majority of whom have lived in Indonesia for generations and have acquired citizenship by birth, are still classified as Chinese on the basis of their place of origin. The ambiguity in their position is also due to the terminology used to classify people. There is a distinction here between the terms suku bangsa and golongan. Suku bangsa, indigenous Indonesian ethnic group. Golongan is used for foreign minorities and is more of a legal term, as we will see in a moment. And this distinction between indigenous and foreign minority Indonesians is based on the colonial legal classification system in what was the Constitution of Netherlands India, the Indische Staatsregeling of 1925. It was transferred to the new Indonesia in 1945 on the basis of Article 2 of the transitory provision, and surprisingly, it has never been abolished. So Indonesia must be one of the few places that still has the constitution from a colonial period. The dualism between indigenous and foreign is also visible in the Indonesian constitution and in the terms used in official discourse about ethnicity in Indonesia. The often used term pribumi literally refers to sons, daughters of the soil, and is contrasted with Indonesian citizens of migrant descent. The ethnic Chinese community today is very heterogeneous. It includes not only the locally born descendants of migrants, referred to as Peranakan, but also overseas Chinese who are foreign citizens. Both groups are administered under the category of foreign Orientals of the colonial provisions, making the Peranakan permanently foreign. The following historical overview will demonstrate how this came about. We can divide Indonesia's colonial history roughly into the period of the Dutch United East India Company from 1602 to 1799, and the subsequent colonial state of Netherlands India from 1800 to 1945. During the rule of the VOC, the Europeans lived in settlements and fortresses, surrounded by a potentially hostile and dangerous local population. Workers from surrounding Sundanese villages were allowed into the first city of Batavia only if they were wearing security stickers showing that their presence had been approved and they had to leave the city at night. It is hardly surprising then that the Dutch immediately began to rely for support on migrant communities, as well as on slaves and on other forms of unfree labor. The non-European population consisted of many slaves and former prisoners of war from Ceylon, Bali, Timor, and the east coast of India, as well as of Chinese from the surroundings of Batavia. They were descendants of Chinese traders and Indonesian women and employed to build the city. The Javanese called them Peranakan, using the Javanese word for womb to indicate that these people were born to Javanese mothers. With expanding work, further Chinese migration was encouraged, and all these Chinese in Batavia were put under the administration of a VOC-appointed Chinese officer. Many of the migrants subsequently converted to Islam, in which case they came under the administration of local headmen. Already at this early stage becomes visible what Immanuel Wallerstein has referred to as the ethnicization of the workforce in the process of colonialism. VOC army and police personnel, for example, came from countries in Europe and from Dutch colonial outposts in Asia. Slaves from other parts of Indonesia were working in particular as domestic servants. And as for the locally born Chinese, their knowledge of local languages and cultures gave them an important role as intermediate traders, moneylenders, and tax farmers. This ultimately led to antagonism with the local peasant majority, and this is persisting in the stereotypical views of Chinese today, as in this cartoon of a Chinese capitalist with his hand on the throat of a common man, or as it says on the shirt, the people. Legally, the VOC soon began to segregate the population and to classify different groups according to their place of origin. This classification determined access to Dutch law and courts. Religion played an important role in the classification and group formation. The European religious wars were still raging, and the Protestantism of the Dutch Reformed Church became the only form of religion which was allowed in the city of Batavia. Protestantism was promoted not just in competition with Islam, but also with the Catholicism of other powers, in particular the Portuguese, whom the Dutch had replaced in Indonesia. According to a statute from 1642, Christians were prohibited from marrying non-Christians, heathens, or Moors, with Moors referring to Muslims from the Indian subcontinent. From the early days of VOC rule, people lived and operated in different quarters under the administration of their own headmen. The number of Chinese migrants expanded with the expansion of VOC business. With the decline of the sugar industry, many lost their income, and there were rumors of a rebellion, and this led in 1740 to a massacre of some 10,000 Chinese by VOC soldiers. Many Chinese fled to Java and converted to Islam. In what in Indonesian history is known as the Chinese War, Chinese rebels attacked VOC settlements together with Javanese forces, but were defeated and from then on subjected to stricter regulations. So in 1766, marriage between Chinese and Muslims became prohibited, separating Islamic Chinese from other Chinese. And already in 1717, the Chinese had been separated from the Javanese when marriage with non-Chinese was prohibited. From the beginning and increasingly after these prohibitions on marriage, Chinese migrant workers married female slaves. The VOC became concerned about Chinese conversion to Islam, also because of loss of head taxes, which the Chinese had to pay, but the Javanese not. It was decreed, therefore, that conversion to Islam did not change their Chinese identity, even if they had severed their link with China. For the VOC, they remained subjected to the regulations for Chinese in spite of their Muslim faith. A few years later, however, they were separated as no longer belonging to the Chinese nation, and a separate captain of Peranakan Chinese was appointed for them. The VOC period also saw the beginnings of a dualism in the court system, with the first Landrat as court for the Indonesian population established in 1747. The involvement of Dutch judges in local disputes required knowledge of local law, and various collections were put together, including one for what was regarded as Chinese law in 1761. The colonial state of Netherlands-India replaced VOC rule from 1800 to 1945. The meaning of the term Peranakan Chinese changed, in particular during a British interregnum, when it lost its association with converted Chinese Muslims and became a racially tainted reference for half-caste Chinese. When the Dutch abolished the separate administration of Chinese Muslims, the term ceased to be used in law, and the Peranakan Chinese became subjected to regulations for Chinese in general. The term foreign Orientals also began to change its meaning. With the Dutch controlling more Indonesian territory, many Indonesian locals were no longer foreign, and the focus was now on Chinese, Arabs, and people from the Indian subcontinent. Included in the regulations for natives in 1847 were Arabs, Moors, Chinese, and all others who are Muslims or heathen. And the same formula was used in the Regeringsreglement in 1854. Because of the economic significance and role as intermediate traders, the government soon began to make exceptions for the foreign Orientals. Although generally equated with Indonesians, all European commercial laws and large parts of the civil code, with the exception of family and inheritance law, were declared applicable to them. Early in the 20th century, this group was then further divided when all European law, with few exceptions, became applicable to the Chinese. And this was confirmed in the Indische Staatsregeling that I mentioned earlier. The increasingly formalized differentiation between ethnic groups also required rules about the interaction between them, and this became the so-called intergentile recht, a field of law using the Latin term intergentes. After independence, it became translated into Indonesian as hukum antar golongan, the law between population groups. It consisted of a mixture of legislation and court decisions. The main institutions were the gelijkstelling, the equalization with Europeans, or assimilation with Indonesians, the voluntary and involuntary submission to European law. In colonial times, an equalization was effected by court decision or by decree. And given the social and economic power structure of Europeans, it's hardly surprising that many people applied for equalization with Europeans. A small number were granted, and these people were then called State-Gesetz Europeans. Applications for assimilations with natives were rare. It meant loss of privilege, but the colonial government, that's interesting, also decreed that foreign Orientals, even if they were Muslims and lived like locals, were still not to be equalized with Indonesians. With the further expansion of the colonial economy and the arrival of the steamship, new waves of Chinese migration arrived. This new migration was supported by treaties China concluded with Western powers, ending its opposition to the settlement of Chinese abroad. The Western colonial powers welcomed the migration of Chinese coolies as a new source of cheap labor for their plantation and mines, in particular after slavery had been abolished. These new immigrants were, however, different from earlier migrants. Because of the easier travel and the removal of restrictions in China, some of them came with families, and they formed enclaves within the existing community. They were referred to as Totok, or full-blooded Chinese, because they tried to keep their Chinese way of life. Much of their social and economic activities were organized on the basis of their respective dialects. With the opening of Dutch schools for Chinese, the Peranakan attended these schools and gradually moved into professional positions, while their traditional positions as middlemen in trade were taken over by these newly arrived migrants. The Peranakan Chinese became entangled in citizenship debates when China introduced a new citizenship law based on descent and claimed Peranakan as Chinese citizens. The Dutch responded by introducing a law based on place of birth for what they called subjects of Netherlands India, because citizenship status was reserved only for Netherlanders born in the Netherlands. Both countries now registered Peranakan Chinese in Netherlands India as their citizens or subjects, respectively. And children of new migrants born in the colony would be registered as Dutch subjects. As foreign Orientals, both Peranakan and Totok fell under Dutch commercial law and parts of the civil code, but under Chinese family and inheritance law, something that was questioned by the Peranakan. They argued that they had their own adat customs, which were a syncretism of traditional Chinese and Javanese principles. But this was disregarded by the authorities, who instead arranged for translations of relevant parts of the code of the Qing dynasty in China, the Ta-Qing Luli. In this way, Peranakan, who had been born in Indonesia for generations, came under legal principles from a country with which they had hardly any connection, and whose language they no longer spoke, but that was regarded as their country of origin. And although almost the entire civil law was declared as applicable to them in 1919, they remained foreign Orientals. This is curious insofar as the category of Europeans now began to include people from Asian countries that had modernized their legal systems and introduced family law similar to the one in the Netherlands, which was the classifying criteria. Japanese, Thais, and Turks became legally treated as Europeans after their law reforms, but not the Chinese, in spite of the reforms in China. When independence was declared in 1945, colonial law remained in force on the basis of the transitional provision of Article 2 of the Constitution. Article 2 was supplemented by a government declaration clarifying that only laws remain in force that are not contradicting the Constitution. Therefore, unless a colonial law is clearly replaced by a new one, invalidation is a matter for the courts. And this has created an ambiguous situation with regards to laws that are quite discriminatory, but were not clearly invalidated. The classification of the legal groups, which we see here again from Article 131 and 63, is a good example because it determined much of the colonial legal system, and other still valid laws are making reference for it, for example, the Civil Code. In 1966, a cabinet instruction ordered the civil registry to no longer use the classifications, but since so many of the old laws remain in force, they are continue to be used in practice. The Peranakan Chinese were in a difficult position when independence arrived because of their double citizenship. At the same time, the process of nation building started using the concept of indigenous introduced into the Constitution and the first citizenship law. Nationality, as you can see here, is regulated in Article 26, and it's often translated simply as citizens shall consist of indigenous Indonesian people and persons of foreign origin who have been legalized as citizens. In fact, the Indonesian language text uses the term bangsa in this context, which according to the dictionary of Eccles and Schädeleit can mean nation, people, race, family, class, group, or type. It could therefore also imply the belonging to an indigenous Indonesian nation and a race-nation concept, as was in fact frequently used in the first half of the 20th century in nationalist discourse in Asia, for example, in Japan and China. The original explanatory memorandum to Article 26 shows the cautious attitude towards the recognition of others as part of this new nation. It says there that persons of other ethnic origins, such as Peranakan Dutch, Peranakan Chinese, and Peranakan Arab, who are resident in Indonesia and recognize Indonesia as their home country and behave loyally towards the Republic of Indonesia, may become nationals. So it's interesting, the Indonesian language text uses the term Peranakan and thereby actually excludes newly arrived migrants with different citizenship. While the Peranakan Dutch left the country for the Netherlands, most Peranakan Chinese regarded Indonesia as their homeland and now had to choose between Chinese and Indonesian citizenship. They had to get a certificate from the Indonesian government that the other citizenship had been relinquished, and subsequently a further document proving their Indonesian citizenship status. This document remained relevant as a proof of citizenship status until it was only recently abolished. Newly arrived migrants with Chinese citizenship needed to become naturalized as Indonesian citizens, but both groups continued to be administered as foreign Orientals. Indonesians of ethnic Chinese descent became particularly targeted during the military-backed so-called New Order government of Indonesia's second president, Suharto, which lasted from 1966 to 1998. Taking over from the left-leaning Sukarno after an aborted military coup, the New Order purged the Indonesian Communist Party and its sympathizers, and Chinese could easily fall into this category because of rumors that mainland China had supported the coup. During the 32 years of the Suharto government, expressions of Chinese identity became extremely restricted, and it was expected of ethnic Chinese to give up their culture and become assimilated. A presidential instruction from 1967 shows the essentialist understanding of Chinese culture. The Chinese religion, belief, and customs in Indonesia, which concentrate on the land of their ancestors and in their manifestation, can cause psychological, mental, and moral influence, which is not proper for Indonesian citizens and becomes a hindrance for the assimilation process, needs to be regulated, and its function placed into proper proportions, it says here. A cabinet circular from the same year addressed what was called the Chinese problem. Ethnic Chinese were now compelled to give up their names and adopt Indonesian ones, and Chinese language material was prohibited. In social and economic life, the distinction between pribumi or ethnic Indonesians and non-pribumi, sometimes called citizens of descent, became very important. As in colonial days, the Chinese were allowed to play a role in business and in some professions, while ethnic Indonesians monopolized political life and careers within the military. Because of the strong international business networks of the Chinese and the political links of Indonesian politicians and civil servants, this led to Chinese-Indonesian collaborative business ventures. The legacy of the population classification continues to affect the interaction between different parts of the population. An example is marriage law. In 1974, the Suharto government introduced a new national law and abolished the colonial mixed marriage decree, which had facilitated interreligious marriages, including for the local population, and together with the relevant parts of the civil code. The new law strengthened the role of religious affiliation in defining the applicable law. It's based on the belief in a supreme God, which is one of 5 principles of Indonesia's state philosophy, Pancasila. The relevant principles clearly make Indonesia a religiously tolerant country in the sense that it allows for various religious beliefs, but it is often misunderstood. It is not a secular country. The marriage law says that the marriage is to be conducted according to the law of religion and belief of the partners, and there can be no marriage outside of these rules. The explanatory memorandum uses the term groups now in a religious sense. But because the rules of religion are very different and can also be prohibitive of interreligious marriage, marriage across groups now requires the conversion of one of the partners. One issue for the Chinese here was for many years a refusal of the authorities to recognize Confucianism as a religion because they regarded it as an expression of Chinese identity. With the legal reforms in the early 2000s, Confucianism was finally recognized, and the Chinese can now marry according to Confucian rites. And there's a small percentage of Chinese now declaring themselves to be Confucianists. Since the end of the Suharto government in 1998, his various successors have reformed the legal system and abolished most of the discriminating laws, as well as promulgated a Racial Discrimination Act. While this is a very important step forward, the definition of race in this act as a group of the population on the basis of physical traits and principles of descent still shows the essentialist criteria which were used earlier for the population groups. As for the indigenous Indonesian terminology in the constitution, a new citizenship law in 2006 repeated the somewhat problematic text of the constitution, but added in an explanatory memorandum that indigenous Indonesian was from now on everyone born as Indonesian citizen who had never acquired another citizenship. So this finally makes the Peranakan Arab, Indian, and Chinese in the public mind members of the indigenous population. But the fact that this important clarification is only to be found in an explanatory memorandum and not in the law itself creates again ambiguity, but it's still an important step forward. A recent controversy regarding citizenship involved the Indonesian Chinese singer Agnes Mo, whose citizenship was questioned after she said in an interview, pointing to her Chinese, German, and Japanese ancestry, that she had no Indonesian blood whatsoever. And a few years earlier, the appointment of Chinese-Indonesian politician Ahok as governor of Jakarta had sparked strong protests as Chinese began now to be appointed to important political positions. Appealing to racial tolerance, the Ministry of Education and Culture last year sponsored an exhibition with the title "Where Are You From?" based on a DNA testing project. It included a promotional video in which Indonesians from different backgrounds and regions are asked where they are from and whether they have been bullied because of racial difference. And the video ends with the statement, "Wherever you are from and whatever your skin color, we are all red and white." Red and white being a reference to the Indonesian flag. Concerning the term Peranakan, it is interesting to note that the distinction between the more recently arrived Totok and long resident Peranakan has largely lost its significance. All Indonesian Chinese are now predominantly Indonesian born, and the distinction has become more of a cultural marker regarding lifestyle. Interestingly, Peranakan culture is now also commercially exploited, mainly in Malaysia and Singapore, where the term is also used. Perhaps the most successful marketing campaign using Peranakan culture is the Singapore Girl campaign of Singapore Airlines. But Peranakan culture is also of interest in Indonesia again, as is visible in this Peranakan-themed restaurant in Jakarta. So over its long history, the term Peranakan has changed from a reference to Indonesian Muslims over a racially tainted understanding as mestizo or mixed blood people in the late colonial period to a simple reference of a person with Chinese origin born in the Malay and Indonesian-speaking countries of Southeast Asia. It's largely associated with the Chinese, but there are Peranakan, Arabs, and Indians as well. In sum, I hope to have shown how the colonial authorities have shaped the population groups based on ethnicity, sometimes mixed with religion, to suit their economic and political needs, and how these classifications need the concerted efforts of reform-minded governments to be abolished. In the process, there is often a contest between ethnic and civic forms of nationalism and different ideas about how inclusive citizenship should be. It's also important to distinguish clearly between such legal ethnic categorization and self-defined notions of identity. The concept of foreign Orientals is a primary example of an imposed legal categorization, whereas Peranakan Chinese, although it was often used in colonial and early post-colonial law, has again also become a self-defined expression of identity. The recent revival of Peranakan culture is a positive sign, as are the many steps taken by Indonesian government since 1998 to abolish the remnants of the colonial legal system and to establish a better understanding of minority groups within the population. Let me conclude by saying that much of what I have been presenting is based, in fact, on joint research on minority issues that I conduct with my wife, Rosie, who is herself a Peranakan Chinese and a sociologist. And we published on this topic in 2017 and have another article in preparation. Initially, we were planning a book comparing different developments in Indonesia, Malaysia, and the Philippines, but this was far too ambitious and is settling now for smaller projects. And I would also like to acknowledge how much I have learned from the writings of Professor Sudargo Gautama at the University of Indonesia, who was my PhD co-supervisor in the 1990s. And he held the chair in Intergentil Recht at the University of Indonesia for the record time of 50 years. He was appointed to it in 1958 until he passed away in 2008. That's my presentation. Thank you very much for listening.
Thank you very much for this wonderful presentation. I think it was really very vibrant, and it was possible to follow you even through this medium we are not so much accustomed to, but more and more. But I think you have done it in such a wonderful way, dear Christoph Antons, that nothing should be added to that. And instead, we are proud that you are a fellow at our center. Thank you very much that you took all the efforts to realize such a fellowship. So once again, thank you very much.